rolling, Gary.
Okay. So I'm going to use a microphone on my lapel since I'm of Italian descent. I tend to talk with my hands sometimes, and the microphone wouldn't work well. Welcome back. As Dana mentioned in her introduction, my practice focuses on guardianships, conservatorships, estates, and trusts. So today I want to walk through the process and steps that I go through when I receive a telephone call from a family member who has a loved one who's been a victim or suffering from a traumatic brain injury. When I get that phone call, there are two questions that come up. First, does the person need a healthcare decision maker, somebody to make healthcare decisions on their behalf and to decide where they're going to live? And the second question is, does the person need a financial decision maker? That is someone to manage their financial affairs and resources. A guardian is a person appointed by the court to make health care decisions for someone who is incapacitated. And the threshold for appointing a guardian requires the court to find by clear and convincing evidence that the person is incapacitated. And the law defines incapacitated as follows, and I'll read you the statute. Incapacitated means a condition in which a person's ability to receive and evaluate information effectively or to communicate decisions is impaired to such an extent that the person presently lacks the capacity to meet the essential requirements for this person's physical health or safety. Meeting the essential requirements for physical health and safety means those actions necessary to provide the health care, food, shelter, clothing, personal hygiene, and other care without which serious physical injury or illness is likely to occur. Now, if the person with the traumatic brain injury is a minor, and that would be somebody under the age of 18, we don't need to worry about a healthcare decision maker being put in place because that is the responsibility of the parents during the child's minority. When the child turns 18, then you'd have to revisit the need for a guardian at that point. A conservator is someone appointed by the court to manage the financial resources of someone who is financially incapable. And again, the court is going to appoint a conservator if there's clear and convincing evidence that the individual is financially incapable, and there's a definition of that in the statute as well. And that is, financially incapable means a condition in which a person is unable to manage financial resources of the person effectively for reasons including, but not limited to, mental illness, mental retardation, physical illness or disability, chronic use of drugs or controlled substances, chronic intoxication, confinement, detention by a foreign power, or disappearance. And manage financial resources means those actions necessary to obtain, administer, and dispose of real and personal property, intangible property, business property, benefits, and income. The process for getting a guardian and or conservator appointed is fairly straightforward, and that starts with a petition that's filed with the court. And the petition alleges why a guardian and or a conservator is needed for this individual. It also provides information about the person that's being proposed to serve as guardian and or conservator. That petition is filed, and then there's a notice that goes out to various individuals, the person that is to be protected and other family members, and the notice gives them 15 days to file objections to the petition. If no objections are filed, then you can submit what is called a limited judgment to the court, and it would likely result in the appointment of a guardian and or conservator without the need for a court hearing or to ever appear before the judge. If there are objections to the petition, then there'll be a hearing set by the court. Typically, the objections are the person for whom you're trying to get a guardian conservator appointed does not feel that he or she is incapacitated or financially incapable. It may also be an objection to the proposed guardian and conservator. The individual may want somebody else other than the person that's being petitioned for. Those hearings happen relatively quick. In the Tri-County area, they can happen within a couple weeks time period from the date the objection's filed. So they happen fairly quick. If there is clear and convincing evidence to support the appointment of a guardian and or conservator, I then explore if there are less restrictive alternatives to the appointment of a guardian or conservator before I even file the petition. As to those less restrictive alternatives, with respect to a guardianship, the person who has the traumatic brain injury may have executed as part of his or her estate plan a document called an advance directive. An advance directive is a form that individuals can fill out, and they can decide and nominate or appoint who they want to serve as a healthcare decision maker for them in the event they become unable to make their own healthcare decisions. The person that's designated in the advance directive to make healthcare decisions is referred to as a healthcare representative. And a valid advance directive might be appropriate alternative to the appointment of a guardian. And in fact, under Oregon law, the decisions of a healthcare representative under an advance directive trump the decisions that are made by a guardian. And the reason for that is the legislature feels that it's important to honor the wishes and desires of somebody when they have capacity as to who they want to make healthcare decisions for them, as opposed to the court appointing somebody that they may not know or may not want. So that's the reason that the decisions of the healthcare representative trump those of the guardian. Now, I said a valid advance directive might be an appropriate alternative to the appointment of a guardian. And here's kind of where an area that is of some concern. So if the person that has the traumatic brain injury is resistant to the decisions that are being made by the healthcare representative under the advance directive, or the individual claims or starts making statements that one can infer that the advance directive is being revoked, if those kind of things start happening, then in my experience, care providers and medical providers will pull back and be reluctant to act upon decisions being made by the healthcare representative, and they'll ask that a guardian be appointed. There seems to be more of a comfort level amongst medical providers and care providers to have a guardian appointed as opposed to a healthcare representative under an advance directive, when you start getting the pushback by the person who designated the individual in his advance directive as a healthcare decision maker. And I get that and understand that, why a guardian would be why care providers would be more receptive to the guardianship. The guardian is a court-appointed person, for one. In addition, the court, once a guardian is appointed, will issue what is called letters of guardianship. And it's a document that looks official, it has a red stamp on it, and it's just something that the care providers and medical providers can have in their file and know that it's a solid decision maker in place. The other thing is, guardianships, unlike an advance directive, cannot just be unilaterally revoked by the person. There's a process for doing that, whereas if it's an advance directive and the person decides to change his mind, they can just unilaterally revoke the advance directive.
I have a question.
Yes.
Is there any way to find out, like years ago I had an advance directive. I don't know where it is, and the person who's named in there is not the person I want. How do you find out?
Then I would suggest you get a new advance directive form, and then the form's going to change the first of the year. So get a new form, fill it out, and put in there, make sure you put in there that you revoke all prior advance directives.
Okay.
And just start brand new. That's the best way to do it.
Thank you.
So,
Where are those available?
when are they available?
The form. Where?
Well, the forms now, the current forms are available. Most hospitals have them. You can get them, but I would, wait until, I don't know when the new form's going to be available yet, if it's out. You can also get the old forms like at Stevens Nest.
That was my question.
Yeah. So if I have a situation where I have an advance directive in place, and we think it's going to work as an alternate to a guardianship, but then problems develop where now we need to do a guardian, a couple things I want to make sure of. I want to make sure that the person that I'm proposing be the guardian be the same person that's in the advance directive to avoid the conflict issue, the power struggle on whose decisions are going to be honored. If it's not the same person, then what I want to make sure is that the healthcare representative under the advance directive agrees to step down as a decision maker as long as there's a guardian in place. And that's going to help resolve any issues that may come up with respect to who has authority. So with respect to conservatorships, there are a couple less restrictive alternatives that should be explored and considered. It may be a situation where the person with a traumatic brain injury has executed as part of his or her estate plan a power of attorney. If that's the case, then you need to look at the power of attorney to see if that's going to be a workable substitute for a conservator. Now, the term power of attorney is thrown around oftentimes as though there's just a generic form of power of attorney and all power of attorneys are equal. And that is absolutely not true. All power of attorneys are different. And you need to look at the power of attorney you're dealing with to make sure you know what it covers and what it doesn't cover. I tell my clients that I can draft the best power of attorney in the world, and it's only as good as the willingness of third parties to honor and recognize it. I personally don't believe that powers of attorney are a suitable substitute for a conservatorship. There's a bunch of reasons why. I don't think it provides adequate protection from the assets of the person being protected. It doesn't provide transparency for what the person is doing as a power of attorney. And that person who has the power of attorney is referred to as an agent or attorney in fact. The power of attorney can be revoked at any time.